public. Obviously, we're still in the middle of a COVID pandemic. You don't see many elected members here this morning. They are on screen, many of them working from home, so it is a kind of hybrid approach. But nonetheless, they'll be listening to everything that's being said and keeping abreast of matters as they pan out. So Lynn has touched on housekeeping with you, likes of mobile phones, etc. Just again, check your mobile phones. Please make sure they're either switched off or onto silent. The call for the sederent and intimation of apologies. Lynn.
Yep, thank you, Chair. Good morning, members. Before I call for the sederent, I would just remind you all that today's proceedings will be recorded and will be subject to delayed broadcast and repeated viewing on the Council's website. In terms of the sederent, Councillor Roberts.
Yep, here, Lynn.
Councillor Jenkins.
Yes, I'm here, thanks.
Councillor Friel. Councillor Friel. You're on mute, Councillor Friel, but I can't see you. We have an apology this morning from Councillor McFadden and an apology from Councillor Mackay. Councillor Cook.
Yes, here, Lynn.
Councillor Maitland.
Here.
Councillor Todd. Councillor Todd. I'll come back to that. We have an apology from Councillor Mayer, an apology from Councillor Neil McGee, an apology from Councillor Crawford, Councillor Bell.
Here, Lynn.
And Councillor Filson.
Yeah.
And Councillor Todd, can I call for your attendance again, please? No, thanks, Chair.
Okay, thanks very much for that, Lynn. Okay, members, at this juncture, can I ask if there's any declarations of interest, and if there is, can you make them known and what the nature is of that interest? Councillor Jenkins.
Yes, thanks. This isn't a declaration of interest, but just for transparency, I was contacted by one of the residents about this planning application. I responded to them that I couldn't possibly make a comment until this hearing took place and I had read the papers. They had concerns over the land ownership, and there I could only suggest that they seek the advice of a solicitor. So I don't think that's material and in any way prevents me from taking part.
Okay, thanks.
Through you, Chair. In terms of this, Councillor Jenkins, and I'm conscious obviously David Mitchell is also on the Planning Committee. In terms of the Code of Conduct, clearly if a member is declaring any interest, how big or small, then they require to then, in the outcome of the application, they would require to leave the committee chamber for the duration of the consideration and determination of the application. However, I'm taking it from what you've said, Councillor Jenkins, in actual fact, you've not made any comment on this and you've not, either by your actions or otherwise, explicitly or impliedly, given the impression that you've formed a view one way or the other on this application. Therefore, while I know you're raising it in the interest of openness and transparency, I'm taking it from what you're actually saying that you're not declaring an interest in the matter.
That's correct. I wasn't sure where on the agenda I should raise that. Just for transparency, I wanted to see it had happened. Okay.
Okay, thanks very much for that. I see Councillor Todd has now joined the meeting. Okay. Item 2 is the hearing procedure. Lynn, can you take us through that, please?
Thank you, Chair. The hearing will begin with the Chief Governance Officer or his representative providing an overview of the application. The objectors and all their agents will present their objections to committee. Members of the committee will then ask questions of the objectors on the submissions made. Members, please note that this is not to be taken as an opportunity to comment on the merits or otherwise of the planning application. The applicant and all their agents will then address the committee in support of the application. Members will then have the opportunity to ask questions on the applicant's submission. Again, members, please note that this is not to be taken as an opportunity to comment on the merits or otherwise of the planning application. At this stage, the hearing will then close. Officers present will then give appropriate clarification on any matters which have been raised during the hearing, and the members will then move to determination. Thank you, Chair.
Okay, thanks very much for that, Lynn. Okay, folks, item 3 on the agenda is planning application number 210118 PP, application for planning permission for change of land to form footway, access points, driveways, private garden ground and drainage works at land East Draffin House, Draffin Mount, Stewarton, East Ayrshire, pages 5 through 63 on your papers. Okay, over to yourself, Craig.
Chair, sorry, through you, Chair. As per the hearing procedure, I wonder if we could maybe just make a couple introductory remarks before we move over to the planning officer to speak to the detail, if that's okay.
Yeah, that's fine, David.
Sorry, Chair, and I won't take long. It was really just to say, given as Councillor Jenkins has touched on, there is, alongside the planning merits of this application, there is also a very clear and contentious legal issue. And what we have tried to do is set out in the paper the respective positions of each of the parties or the groups of parties between the developer, the residents and the council. In essence, and colleagues will deal with this in more detail, but in terms of the overview, in essence, the position of the residents is they own the strip of land in question in common between, I believe, 13 of them, and they have exhibited a title certificate to that effect. The developer's position is stated in the paper to be they're aware of that, but they have their own view on the validity of that, and that relates to their view of the process followed by the keeper at the Registers of Scotland. It's not the function of the planning authority to act like a court and determine private civil law property matters. It's also not an impediment or a prerequisite for the planning process that these matters of ownership be absolutely clarified and bottomed out. Personally, I would prefer that they were in any instance, not just this one, because it doesn't always behove well if the planning authority has been put in a position of granting a consent that other people are arguing is not capable of being implemented. But unfortunately for other parties, as far as the council is concerned, as far as the statutory planning system is concerned, it is not for the council to seek to referee what is a private law dispute between various parties. What we have done as planning authority is try to set out in detail, factually and accurately, the respective positions of the parties, as well as the council's understanding of matters. But the fundamental point is to allow the committee today to focus on the planning merits of this application. I just thought I would address that one major legal issue, because it has probably taken as much time in terms of the process and application of a number of officers as the actual determination or assessment of the application and the preparation of the report. And that's not a complaint, that's just an observation, because the situation is what it is. It's not a situation that the council's making, and it's not either a function or in the gift of the council to determine the legal matters or the matter of ownership. The fundamental point is, whatever the committee decides today, should you decide to grant consent, it will still be incumbent on the developer to make sure they've secured all necessary legal rights, permissions and otherwise to carry out the works. And if you grant the consent, we are not in any way suggesting that they have those legal rights. The granting of consent does not afford the right to the legal right to deliver the development on property with your ownership. They would still need to resolve that. So it was just to give context to what I think will be a recurring theme, but actually it has no direct bearing, and I wish it did, that the statute position is what it is. It has no direct bearing on the determination of the merits of the application on its planning merits. So I appreciate members are aware of that, but we are in a public hearing, so it was just to give that clarification and set the context prior to bringing the case officer in to speak to the detail of the report, Chair. I thank you, and members. Thank you.
Okay, thanks very much for that, David. I think members will be aware there's quite a lot in the report that highlights the salient issues in terms of the land ownership point. So, Graham, I'll pass over to yourself.
Craig.
Craig, sorry.
Thank you, Chair. Good morning, everyone. This application is before you today because, as per the scheme of delegation, the application has attracted more than 10 objections. The application site itself is a narrow strip of land, approximately 421 square metres, located on the eastern side of Draffin Mount, to the south of Draffin House, and bounded by the residential development site Draffin East to the east, two-storey residential dwellings to the west, Loudon Street to the south. The site is essentially maintained grass with a number of trees and recently planted hedging along the eastern boundary of the site. The application site is located within the settlement boundary of Stewarton under the provisions of the East Ayrshire Local Development Plan. Members will note, starting at paragraph 7 of the committee report, the lengthy background and planning history to this development and the application site. This application proposes to change the use of the land to form a footway, access points, driveways, private garden ground for the plots within the Draffin development and drainage works. If I can now refer to the slides. Are they working? Shared the tray. Shared. Why is that not working? Is that it? Okay. Excellent. Technology. The first slide is a general map of Stewarton, which shows the application site circled red towards the southeast of the Stewarton town centre. The Draffin East development site is essentially to the right of that circle, the application site. Draffin Mountain residential dwellings are to the left there of the circle, within the circle to the left of the application site. The next slide is a location plan of the application site outlined in red, with land owned by the applicant outlined in blue. The blue outlined site is the Draffin East residential development site. The next slide is a more detailed site plan of the application site, which shows the existing trees on the site. It shows the footway, driveways, pathways, and the front garden area of those plots within the Draffin Mount development. Next plan is a drainage plan submitted by the applicant in support of the application. It covers the whole of the Draffin development site as well as the red line application site, which you can see on the left of the plan. It's basically showing all the foul water, surface water drainage. It shows the foul and surface water within the application site as well as into Draffin Mount, the adopted road itself. Next plan is the local plan map, extract from showing the Stewarton settlement boundary. Again, the application site's located with that red circle. The orange shaded areas of the Draffin development site, the allocated site, which basically gives you an idea of where it's situated within the settlement boundary. The next slide is site visit photos. That shows the strip of land in question, the trees on the application site. It shows it's maintained, recently planted hedging along the boundary. That's looking south down towards Loudon Street. The residential properties of Draffin Mount are located to the right of that picture, and the development site of Draffin East, currently underway, is to the left of that photograph. Next photo is basically swinging around Draffin Mounts. That shows one of the residential dwellings. Again, looking south down towards Loudon Street. This photo is looking north up towards the listed building at Draffin Mount. Again, it shows the application site, existing trees, hedging, and the existing residential dwellings of Draffin Mount there on the left. The development site at Draffin East is to the right of that photo. Again, this is another shot looking northwards, just showing the application site again, giving a bit of scope. These are the residential properties of Draffin Mount opposite the application site, looking onto the site. Again, the residential properties. It's just another perspective showing the recently planted hedging. This is the site again, looking south towards Loudon Street. And the next photos are essentially of the swinging around, showing the development as is currently taking place, Draffin East. And there are all the slides. If you want me, I'll just leave the site plan up, if that's all right. You happy to leave the site plan up? We've had no objections from consultees comprising the Ayrshire Roads Alliance, Flooding and Scottish Water. We've received objections to the proposal from 20 individuals. We have no letters of support. Points raised in the objections have been summarised and responded to within the report presented to committee. The Town and Country Scotland Act 1997, as amended, requires that applications are determined in accordance with the development plan unless material considerations indicate otherwise. Development plan comprises the adopted East Ayrshire Local Development Plan 2017 and the Minerals Local Development Plan 13th of January 2020. In this instance, the adopted East Ayrshire Local Development Plan 2017 contains the relevant policies given the subject matter of the application. Given the terms of Section 25 and 37(2) of the Act as amended, the application should be approved if in accordance with the development plan unless material considerations indicate otherwise. Taking account of the points discussed above, it is concluded that the proposal is in accordance with the adopted East Ayrshire Local Development Plan 2017. Material considerations are noted and the application is considered to be appropriate to the provision of the local development plan and is not considered to have an unacceptable adverse impact on the residential amenity or general amenity of the area. The letters of objection, whilst noted, do not warrant refusal of the application. The application is therefore recommended for approval with conditions which are listed at the end of the report. Before I hand back to the Chair for members to discuss the applications, it's noted that the Ayrshire Roads Alliance have reviewed their recommended conditions for this planning application proposal and have advised that as surface water management is being addressed on another application for the wider development site at Draffin, there is no requirement for conditions, being conditions 1 and 2 of the report, to be applied on this application. Thank you, Chair.
Okay, thanks very much for that, Craig. Okay, members, obviously, in respect to the numbers of objections, we do have a hearing this morning, and we've got Martin Hannah wishing to address the committee on behalf of numerous of the residents. Martin, are you here? Okay. Robert, do you want to show Martin where he can make his representation from in relation to his objections and other objections as well? Members, I'm proposing 15-20 minutes for Martin, if that's agreeable and acceptable. Okay, good morning again, Martin. You've got 15-20 minutes.
20, Chair.
Okay, we'll go 20. Allow a bit of leeway.
Good morning, Chairman and Councillors. Thank you for the opportunity to address the committee this morning. My name is Martin Hannah. I'm a chartered town planner and I've worked in this field for the past 33 years in private practice, in the development industry and in government, including a period overseas as the Departmental Service Head of Planning and Building Control on behalf of the Crown. I have considerable practical experience in land management and the planning and delivery of housing development as a senior manager and director. My family home is at number 23 Draffin Mount in Stewarton, and I'm here today as a landowner and objector. I also speak on behalf of several of my neighbours present here behind me while watching these proceedings live from elsewhere. They also have an ownership interest in this land and have lodged objections to this planning application. I am an original resident of Draffin Mount. I self-built my home adjacent to Draffin House and purchased the plot of land from John Dickey Homes in 2002. At the time, I was the land director with the house building company. I worked with this business between 2001 and 2006. I therefore dealt with the land and planning aspects of the development of Draffin Mount and Stainbury engaged the services of Miller Partnership Architects, Joanne Brindley Associates, the landscape architects, and WSP civil engineers to design the Draffin development, which at that time was branded as Kirkford Grove. I also had a significant hand in the drafting of the Deed of Conditions by solicitors Macleay, Murray and Spence, decisions about the future land management and the appointment of the management factor, Hacking and Pattison. And this factor still maintains the common parks and open spaces to this very day. But personally, I am not opposed to the concept of new housing at Draffin Park, although I admit there are aspects of the project that I do question. But my real concern is about planning handling and process. I've looked closely at historic and more recent planning decisions by this council, and I have grounds to still challenge the legitimacy of the housing development now underway. But I don't intend to elaborate upon this here because time is short. The Draffin Mount residents' opposition to this planning application is because the strip of land that forms the planning application...
Martin, sorry to interrupt you. Okay, folks, can you just please ensure that your microphones are switched off to allow Martin a bit of peace and quiet to do his presentation? Okay, sorry about that, Martin.
Okay, Chairman, thank you very much. So the Draffin Mount's residents' opposition to this planning application is because the strip of land that forms the planning application site forms part of the amenity space that was landscaped and planted by John Dickey Homes, established 20 years ago. And because, along with my neighbours, we own and pay for the maintenance of this land. So, we just don't want our trees felled, nor the land bulldozed by Avant Homes to be handed over as front garden ground to someone else, who will then not be required to contribute towards the upkeep and maintenance or the insurance of the remaining open spaces. Now, our titles specify that these open spaces and common parks should be retained for the amenity of residents. We do not look kindly upon this speculative planning application, nor the opportunism involved. When John Dickey Homes obtained planning permission for new homes and the refurbishment of Draffin Farmhouse, the builder was directed to ensure that the setting of the listed farmhouse was safeguarded. I recollect this very clearly because my own self-built house design was modified at the council's direction to better respect the character and setting of the listed building. Land, including the current application site, was therefore set aside for the purposes of open space provision, to benefit the amenity of development and to safeguard the setting of the listed building. Now, this land is termed the common parks, and it was transferred to resident management upon completion of the Draffin Mount development under a deed of conditions. And this was the practice at the time. This was all explained to and understood by the home buyers at the point of sale. And at least this was the understanding of everyone until Avant Homes suddenly appeared on the scene out of the blue a year ago to start to question our ownership. I'm going to return to that point momentarily. In the application form, agents for the applicant described the application site as vacant land. The application site is not vacant or unoccupied. It is landscaped open space that is maintained fortnightly throughout the summer period and monthly during winter time by a factor employed by the residents under an approved scheme. We insure the land, we look after the land, and we've always paid for it. Our land certificates confirm that we own it. Although it may not seem like a significant area of land, it still contributes towards a coherent and planned landscape scheme that was previously approved by the Planning Authority. There is no good reason to set this arrangement aside now. The slides show the trees with the leaves off during winter time, but when in full leaf during the summer months, the planted trees provide an attractive setting and entrance to our street. And the open aspects over the grass area, the trees, the new hedge planting, they're still of value to the people sitting behind me, particularly the householders living in numbers 1 to 5 Draffin Mount opposite. Now, your planning officials have produced some old plan extracts in your report, and they've presented some contorted and unconvincing justification why this landscape space should not be defended. But what they failed to do is produce the approved landscaping scheme that was prepared by landscape architects Brindley Associates. And why exactly is that? Well, I suggest it's because the land does form private amenity open space, always intended to serve the Draffin development, and our deed of conditions, drafted by John Dickey Holmes, obligates the homeowners to maintain it as such. Adopted council planning policies in the local development plan expressly protect such land from development. Correct assessment and determination under the development plan policies does not support the change of use of this land. And if the council conducts its statutory duties fairly, consistently and with probity, this application must be refused. I've exhibited to this council my own land certificate and the deed of conditions to corroborate my part ownership. My neighbours, who sit behind me, have also recently approached the keeper in response to this applicant's assertion that the land is ownerless, and their titles have all similarly been rectified and updated. These land certificates provide a state-backed guarantee of title. The applicant does not possess title or claim of possession upon this land, and these murmurings about disagreement with the keeper and seeking Queen's Counsel opinion does not change this fact. And if they wish to challenge the established and factual position, they will need to challenge the keeper and bring their case to the Lands Tribunal. But even then, they have no interest in this land. It's been possessed and maintained by us for 2 decades. In the past fortnight, the developer has trespassed upon and damaged the land to construct telecoms infrastructure, construction of a footpath, which has preempted the outcome of this committee hearing. I raised this with Planning Enforcement and the Ayrshire Roads Alliance, but no action has been taken by the council thus far. I've not even had the courtesy of a response. So the planning officer recommendation in the report and handling comes as no real surprise to us, but it's still wrong. While the planning officers have resorted to the familiar refrain that ownership is a civil matter, not a material planning consideration, this is not entirely correct. Planning law still requires owner notification, yet we've not been owner notified by the applicant. This reckless disregard for the requirements to owner notify and correctly certify the application form, well, that used to be treated as a serious matter. But the planning authority should be satisfied about ownership and certain practicalities before discharging fundamental conditions regulating access and drainage to major development. A landowner must also sign up for a planning agreement required under Section 75 of the Act. Such a planning agreement regulates the implementation of the Draffin Park development, which was registered in 2012. The council will receive over £166,000 from this development and may have a financial interest and motivation in this development proceeding without any more problems or undue delay. But there's nothing in your report and handling about that. Although the 2012 planning agreement predates Avon Home's involvement, I still cannot remember anyone asking the owners to sign a thing. The ownership of the planning application site and the correct definition of the planning unit are of more than abstract importance. The applicant seeks to take land that does not belong to them, to construct individual driveway accesses and services and drainage, but they also want to use this land to provide front garden areas to enable the future development of 7 dwellings. These dwellings are currently without a valid means of access or drainage, and this application is required urgently to subsume the land into a larger scheme of housing development numbering 150 homes. So please think about that situation and how we got here. The applicant and the planning officials want to turn our small street upside down to fix a planning and legal problem that's not of our making, instead of insisting upon the necessary changes to the Draffin Park development. Now, to explain how we got here would require more time than I have available this morning, but I do wish to state, for the record, that back in July 2015, I attended a planning hearing exactly like this one to object to the application for requisite approval, because it was so obviously defective. The original applicant, Diane Fraser, indicated the same proposal affecting Draffin Mount and a foul water sewer serving Draffin Park cutting right across my private driveway access. And I expressed concerns then about defective process, assessment and handling. But my objections were ignored. And that's the reason why 6 years later, we're all back in this room. The development of Draffin Park has progressed while fundamental issues around the cadastral of the planning permission, the means of foul water drainage and vehicular access, and breaches of planning control go unresolved. The application for planning permission is ill considered because the arrangement proposed by the applicant is repugnant to the ownership of the proposed 7 houses. Now, I want to put this across to you as plainly as I can. If committee approves this planning application today, it's going to create a situation that the driveways and the front gardens of 7 houses will be owned by the homeowners and objectors living opposite, these people here. The applicant wants you to think that this application is some form of straightforward correction, but it's not. You have a 59-page lengthy report on handling, and that's a bit of a telltale that this is not a straightforward matter. It's highlighted some unusual decisions by the planning authority. This application is not a question of regularising a small problem. It's an attempt at a land grab to expropriate and develop land that is already owned by a group of homeowners. It's an attempt to remedy past planning handling errors. It's an attempt to subvert the approved landscaping scheme and settled land management arrangements to profit a developer and inconvenience my neighbours. And it's plainly wrong. I hope that the planning authority will choose not to repeat history this morning. This committee should uphold adopted development plan policy by rejecting the officer recommendation before you. Planning permission should be refused. Now, the reasoning I offer you for refusal of planning permission is that the proposed development is contrary to adopted development plan policies OP1, Res 1, Res 11 and ENV 9, as it will have a detrimental impact upon residential amenity and the established street scene. It will erode the provision of private open space serving existing development, likely to be harmful to the principles of good placemaking. If you are minded to grant planning permission, please consider carefully the reputational damage to East Ayrshire Council and the planning process when 7 new home buyers react to the news that someone else owns their front gardens and driveways and demand answers about how this could possibly happen. So respectfully, Chairman and Councillors, I ask you to reject the officer recommendation and to refuse planning permission. Thank you.
Okay, thanks very much for that, Martin. A large part of your presentation has been to do with the issue of land ownership, and we will be hearing from the applicant just shortly in regard to their representation. But in this report here, it's tried to cover and give a reasonable context in regard to the historical aspect of the land ownership. But can I take you folks to page 17, paragraph 38? And that relates to some of the paragraphs above. And paragraph 38 reads, as can be seen above, the matter regarding the land ownership of the subject land is a private legal matter. Would you agree with that, Martin?
It's a familiar refrain, Chairman, that land ownership is a private legal matter. As I've just set out in my statement, it's really not that clear cut. We live in the real world, and this is real development affecting real people's lives. These are driveways and services that have been run over an area of open space that is protected by council policy. The council approved the landscaping scheme. If you cast your mind back 20 years when this development of Draffin Mount was originally approved, this was all set out in landscape plans produced by Brindley Associates. The council stamped those drawings as approved. So I think these issues are all mixed up together, frankly. I don't think you can make a planning decision in a vacuum and neatly try to put the ownership issue in a box. It's just not as simple as that.
But I think there's an aspect of us being caught in the middle is not the right terminology, but we're being asked here to make a decision that does not necessarily have a locus to the application. The land ownership, you heard from the solicitor to the council at the outset, it's not a material consideration who owns the land. That is a private legal matter between the residents and the applicant. That came through loud and clear.
Well, let me come back to that point, Chairman. Recently, Avon Homes has submitted a further application under Section 42 of the Act. Now, we're not here to discuss that particular planning application, but this particular applicant wants to vary conditions attached to that planning permission. Now, again, Avon Homes have failed to owner notify us as owners. Now, they should have done that. That's a legal requirement. Moreover, an application under Section 42 involves granting a new planning permission for the entire site. As far as I'm concerned, the entire development includes these driveways and gardens serving plots 1 to 7 on Giraffe and Mount. Now, if you're issuing a new planning permission under Section 42 of the Act, strictly speaking, the applicant should be asked to transfer the planning agreement over into the new planning permission. Now, are we going to be asked to sign up to that planning agreement as owners? This is why you cannot separate out the issue of ownership as neatly as you seek to do, because these issues are all they're all meshed together. And I know it's difficult, but look, what I've done here this morning is set out some very solid policy reasons why you should be refusing this planning application. It is managed open space. There is a factor that cuts the grass, maintains it, looks after the trees. We insure it, we own it, we maintain it. This has been going on for 2 decades. We're doing it actually to comply with a planning condition attached to the original John Dickey planning permission. It's all set out in our deed of conditions. Why would you as a planning authority seek to upset that? If you act consistently with other recent planning decisions that you've made, you should be refusing this application. Why on earth are you recommending approval?
Well, I think that's something that will be determined further on. But I do take your point, and I think I do recognise that the residents have been maintaining that land, the strip of land for 20 years. That's no in dispute. Members, any questions at all? Councillor Jenkins.
Hi, Martin. Thank you very much. I'll just turn so I can face you, if that's all right.
Of course.
Could you just go over for me again the reasons for the objection that you said it was contrary to OP1, and I caught that. I didn't catch the rest of them, so I want to take a note. Thank you.
The reasoning.
Just the numbers, please.
Of course, policies.
Yeah.
OP1,
yeah.
Which is the settlement strategy policy. Also, residential policies Res 1 and Res 11, and policy ENV9.
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 Okay. Thank you very much. Thank you.
Okay.
That's fine. Thank you,
Members, any questions for Martin? Councillor Todd.
Thanks, Convener. Morning, Martin. To elaborate a wee bit more, please. You touched on a part of your representation that the proposed development that's in front of us today could have an alternative routing if the planning application for housing did go ahead. You touched on an alternative route. Could you expand on that, please?
Certainly, Councillor Todd. The development of Draffin Park is being accessed via an internal development road, which in itself is accessed via a newly constructed roundabout that connects to Loudon Street. Now, this applicant has only in the past week or two submitted a Section 42 application to vary conditions. They could easily have used that opportunity to submit a variation to planning permission involving some alteration of the site layout, reconfiguring and rearranging the house plots to allow them to be accessed via the internal development road that serves the rest of the development. It's not beyond the wit of man to do that.
Is that okay, Councillor Todd? Yeah. Martin, I've got one more question for you. And it relates to page 8, paragraph 1213. Have you got a copy of the notes in front of you?
Not in front of me, Councillor. If you just read it back to me, that I'm familiar with it.
Yeah, it's an excerpt from an approved site layout plan, and that relates to 140903. Robert, do you have a spare set of notes handy?
We don't, sorry, Chair, we don't have hard copies available.
Right, okay.
Sorry, Chair, I can share mine.
Okay, if you wouldn't mind handing it back, if that's okay, Gordon.
I'll need it back, obviously.
It's page 8. And it's the excerpt of the approved site layout plan.
Yes, I have that.
Okay, now that goes on to say, underlined below, it is noted from the excerpt above that the red line application site includes the strip of land that is the subject of this current planning application along the eastern side of Draffin Mount. The approved plan also clearly shows the proposed dwellings fronting onto Draffin Mount with individual driveway access off Draffin Mount. Now this is back in 2014. Now, in regard to the land ownership, I know we're coming back to that, but this particular excerpt, that clearly shows my interpretation of access onto Draffin Mount, even going back 2014. So what did you do at that point, as owners, in regard to this particular consultation?
Yeah, so I mentioned in my statement a moment ago that I actually attended a hearing virtually like this one in the July of 2015 when that particular application was considered. At the time, I came back from overseas. I was actually the head of planning in the South Atlantic at the time, and I came back to attend that hearing. The application that you refer to, and this drawing refers to, is a requisite approval under reference 140903 AMC PPP. Now, the difficulty with that, as I think the Council's former Deputy Chief Executive now accepts, is that this is not the planning permission. The planning permission is the planning permission that was granted in 2012. After a near 10, 11-year delay, it was a planning application that had been lodged in 2001, I believe, and had been assisted for whatever reason, but was only actually determined by the Council in 2012. 3-year lifetime. It would normally expire in December of 2015. So that drawing that is in your papers and that reference 903 AMCPP is a requisite approval. And it was defective. And it was defective because the cadastral of that requisite approval did not marry up with the cadastral or boundary of the original planning permission in principle. Now, we all objected on those grounds. And I made it clear that they couldn't access out onto Draffin Mount because of reasons of ownership. And the Council, it's still a mystery to me, but the Council overruled those objections and granted that particular application. They also, incidentally, granted the route of the foul water drain. So you discharged a matter of requisite approval, the drainage, even though the foul water drain went off-piste. It left the Draffin Park development and cut straight across the driveway that was owned by Hugh Morton and myself. And we said, look, you're not on, because that's private land, and you haven't even included that within the cadastral of your planning permission. But if I refer you back to the original planning permission in principle, that's the permission granted in 2012 under the 01/0859/OL. That is the permission. Yeah, that always referred to access to this development being from Cutstraw Road and, more importantly, Loudon Street. They always anticipated a main access from Loudon Street. They also thought about an access onto Cutstraw Road. And these applications were supported by a transport statement. They made that abundantly clear. There was never any suggestion of an access out onto Draffin Mount. That only came about as a result of the requisite approval application that we have consistently objected to and said, you're not on, we own it, it's factored managed open space. Now, You disregarded those objections back in 2015, and that's exactly why we're back here today. I would ask you not to repeat that mistake.
Well, that's your opinion with the greatest of respect.
Of course.
Members, any further points, any further questions for Martin in terms of his presentation? No, I don't see any. Okay, Martin, thanks very much. Okay.
Appreciate it. Thank you.
We have the applicant for the Homes Scotland, Gary Mappin. Good morning, Gary. Thanks for coming this morning. Members, I'm going to afford the same time to the applicant as what we did to Martin in regard to his representation of the owners. So 20 minutes, is that okay? Sorry, maximum 15?
Maximum 15 or other such time as the committee agree.
Okay, 15 it is.
Thank you, Chair, members of the committee, for the opportunity to speak this morning. I'll probably only take 5 minutes. Excuse me. My name is Gary Mappin. I'm a Chartered Town Planner and Director of ICINI Projects, planning consultants to Avant Homes. We received the Planning Officer's report last week and reviewed that. Note the comprehensive nature of how it has assessed the proposal against the LDP policies and other considerations, and clearly welcome the conclusions. I think what's particularly welcome is the clarification that land ownership is not a material planning consideration, and I don't believe that you as members of the committee would want to be addressing private property matters through the planning process. This application is linked to the delivery of a wider site allocated in your local development plan, and Avant are now well underway with delivering that project. Avant bought the site with the benefit of not only an outline planning permission, but an approval of matters specified in conditions that has not been object of any legal challenge or revocation. And that's the approval and the plan referenced on page 8 of the committee report. But notwithstanding that, it was agreed with your planning service that our clients would seek to regularise the position through submission of this application, which itself mirrors the layout that was approved in July 2015. If the application is approved today, Avant Homes would still only proceed with the development once the property matter have been resolved. And I don't think a scenario where that site is developed or houses sold to individuals would arise until that matter is clarified. I hope you'll support your officer's recommendation this morning. Thank you for the opportunity to speak to the committee, and I'd be happy to answer any questions. Thank you.
Okay, thanks very much for that, Gary. Members, do you have any questions for Gary in terms of his presentation? Gary, I've got, sorry, Councillor Todd, and then I'll come in.
Thanks, convener. Hi, Gary. It's the same question that I asked previously. Is there an alternative route that would alleviate all the problems that were encountered today in terms of objections? Because, as you say, nothing would progress until the legal matters were sorted out, and that could take a long period of time. And when you're building, you want to get the houses up as quick as possible. So if there was an alternative route, could that alleviate the problems? Thank you.
I can't answer that specifically, Councillor, because it's not something I've been asked to consider in detail. As I mentioned, this proposal is in accordance with, excuse me, the wider development proposal and the layout of that development. That would have to be considered as a whole, I believe, if this application wasn't approved today, or indeed if it was and the land ownership position wasn't subsequently resolved. So I I can't answer it other than to say if the matter wasn't resolved from a property ownership perspective, then clearly Avant Homes would have to reconsider the implications on the wider development.
Is that okay, Jim? Okay. Councillor Cook, Tom.
Thanks, Chair. No, thanks, Gary. I'm just looking, I think, just to clarify what you said there. When Mr. Hanna had said that we could be in a position where the new houses in Draffin Mount could have their gardens owned by the existing residents of Draffin Mount. I think what you said was that would not proceed, the building of these houses would not proceed, or the sale of them, until that matter was satisfied legally, so that the owners of these properties would not have their gardens owned by somebody else.
I would say, Councillor, that's my opinion, but I'm a chartered town planner. I'm afraid I'm not a lawyer, and I suppose that goes to the heart of this issue in how the planning process is not there to address private property matters. But I think from a practical perspective, I think that's entirely likely to be the position that Avant Homes wouldn't even begin the development until the property matters are entirely clarified.
Thanks very much.
Okay, Tom, thanks. David, do you want to come in at this point?
Yeah, Chair, just 2 points in the back of that, thanks. One would be the general point that we will, of course, give the committee members appropriate legal advice at the appropriate stage of the hearing on any matters, and we'll be happy to do so. And a general observation, I cannot think of a solicitor in Scotland who would advise a client to buy a house if the driveway and the ownership of the driveway was in dispute. And I'm not being glib about that. There are other steps that require. People have a duty of care to advise their clients, and any solicitor looking at this title position is going to have a job to do to fulfil that duty of care, unless, as both parties have indicated, it is resolved somewhere and by some means. So the bottom line is, as I say, we will deal with that, and the committee is entitled to take any legal advice it needs in closed session after the open session, and we'll be happy to take any members' further queries on that. But that's the general position. And at the end of the day, for Avant to sell these homes, they will need to be able to show they have the title, and that would include all of it, because I can't see anybody having a solicitor advise them to buy those homes without that title having been sorted out. And as Mr. Hanna has put it in another way, nobody's going to be buying a house in the knowledge that the driveway is owned by a third party. So it would need to be resolved, but as I say, any further advice we're happy to give to members as they're entitled to seek and receive at a later stage of the process. Thanks, Chair.
No, thanks, David. I was going to ask legal to come in anyway. Councillor Jenkins, Gordon.
Yeah, okay. I don't know if I'm confused, or I just need a clarification. The part we were talking about, paragraph 8, I didn't quite understand that. In 2016, planning permission was obtained to use that strip of land that this application is for the purposes that it's being used for. Is that the case? And
is that a question for the developer?
Yes, sorry. Is that the case? I can't understand if planning permission was given then, why we're here today. Perhaps it's a question for officers.
Do you want to come in on that, Gary?
To be fair, it's probably a question for the officers, but I mean, excuse me, in my understanding of it, Councillor, is that the approval in July was for matters pursuant to the original outline planning permission. However, the red line of that permission in July 2015 isn't contiguous with the outline planning permission. So hence the reason that this application regularizes that small strip that's the where there's a discrepancy. But as I said before, that notwithstanding that permission under reference 140903 was issued, and that's never been revoked or subject to legal challenge.
And I think this is where we need to be careful. We need to look and be focused on what's before us. The exact wording, the planning application that we're dealing with, application for planning permission for change of land to form footway access points, driveways, private garden ground and drainage works at land East Draffin House, Draffin Mount. So this is the application we're dealing with. Yes, there is a lot of historical context in regard to what has gone before, but we have to deal with what's in front of us today.
Accept that, Chair. I just wanted to make sure I understood.
No, that's okay. Okay, members, is there any further questions? No, I think that's you, Gary. Thanks very much for coming.
Thank you, Chair.
Okay, members, the hearing's closed. It might be worth hearing from some of the officers. I'll bring Care in regard to aspects to do with roads, flooding, etc. There is some comments on the report. Some will also be picked up by Craig. Anything for yourself, Care?
Thanks, Chair. No, not a great deal to say, Chair. Obviously, the wider development has been covered by a road construction consent approval from the Ayrshire Roads Alliance. The works for this, in terms of the installation of the fill sewer and the surface water drain that would connect into the existing systems, that they will require permit applications and approvals for those works to go ahead. But we had no objection to the application in front of us today, Chair, in terms of access, parking or road safety. So thanks, Chair.
Okay, thanks for that, Care. Okay, Craig, do you want to do a round off of some of the points that was raised and provide adequate responses, please?
Thank you, Chair. Can you hear me all right? Yeah. Yeah, I guess the main issues raised are from the objections and the material planning considerations. A number of issues were raised, some material, some not. At the heart of it is the land ownership matter, which, as everyone's heard, which is a difficult situation, and obviously it's whether it's not a material planning consideration, it's a private legal matter. The other issues material to the application and the relevant policies of the East Ayrshire Local Plan have been considered in detail, and it's deemed that overall the proposal is in compliance with the relevant policies in the local plan, and that it would not have a substantial detrimental impact on residential amenity or the amenity of the locale, hence the recommendation in the report. Thank you, Chair.
Okay, thanks, Craig. Okay, one of our legal representatives come in, maybe yourself, Craig.
Thank you, Chair. Just a couple of things, and I will be unusually perhaps brief, because I'm conscious obviously that David Mitchell has come in already on a couple of matters. But I think to essentially, members, I know that there were a couple of questions there about could there be alternative accesses in terms of this proposed application, but members, we have to deal with this application that is currently before us, not what we may wish or what you may look for. It is essentially an application for change of land to form the footway, access points, driveway, private garden ground, etc., is set out in the heading of the report on page 5 of your papers. So that is the application that you require to consider and determine before you this morning. As has already been said, land ownership is not a material planning consideration. The example that I often give to members, and members will have heard this before, is that I can make an application for planning permission to build a dwelling house in the car park here at the council headquarters at London Road. And as long as that application complies with the development plan policies, or where there are material considerations that would justify its construction, planning permission should then follow thereon and be granted. That doesn't mean to say that I own the land, nor does it indicate, as David has said previously, infer that I own the land. That would still require me thereafter to negotiate with the landowner to allow that application and the decision to be formally implemented. The same is the position here. We are not the arbiter, we're not the final decision maker on land ownership. What we're here to do is to determine this application on its planning merits in accordance with the development plan, unless there are material considerations that indicate otherwise. You will see that it's a full report, members, and we have set out at some length the issues, and the relevant assessment against the development plan is contained within the papers at pages 42 through to page 49, where there's an assessment against the material considerations. Of note, there has been a full assessment within the report of the relevant planning policies that include OP1, Res 1, Res 11, T1, IN4, ENV1, ENV9 and OP1, and that is fully set out within your papers. I think it is of note that in terms of the private open space, you will see at page 43 of the report in the 6th paragraph, and it's in the bold, which is the planning assessment carried out by the officer, that the proposal will not detract from the private open space provision of those dwellings which front Draff and Mount. And I raised that just in reference to one of the responses from the objector in this. There is a full assessment, members, and clearly the recommendation is there for you to consider. If there are any further legal issues that you wish to have addressed, I'm happy to answer them.
Okay, thanks for that, Craig. Members, is there any further legal issues that you'd wish clarification on from either Craig or David? No, Councillor Cook, Tom?
Thanks, thanks, Chair. No, I'm just looking for clarification because Mr. Hanna in his submission earlier seemed to indicate that the Council Legal Department had made a wrong decision in the past, which is why we got to this, and I just wondered if we could maybe get clarification on that. I think that was back to the 2014 application.
Okay, thanks, Tom.
No, I'll take that one, Chair.
Okay,
no, Councillor Cook. What Mr. Hanna said was that the Planning Committee in 2015 made the decision that he felt was legally challengeable. All the decisions that have been taken, all the decisions that are set out in the planning history have either been taken by previously the Planning Committee, or if they were done under delegated powers by my predecessor, the former Head of Planning and Economic Development, who granted a recent, before he left last year, granted a non-material variation, which is referred to and played out in the papers. So the planning history is either reflective of, and the issues that arise and the possibility of legal challenge, whether it wasn't taken, as Mr. Hanna's referred to, refers to either decisions taken by the Planning Committee or decisions taken by my predecessor under delegated authority. It's not a question of prior legal advice, I don't believe, being challenged. There was a review in the sense that I believe Mr. Hanna complained about aspects of this, and there was a reference made quite rightly by Mr. Hanna to a complaint he submitted that was responded to by Alec McPhee, who, as you will recall, previously had responsibility for planning and economic development, sitting above Michael Keane as the head of service. And I'm not au fait with that complaint response, but that was certainly, there was legal advice given in relation to that, but that's a separate matter. But the decisions taken here and set out in the planning history of the paper were either taken by the committee in previous times or by my predecessor under delegated authority. That's my understanding of the situation. But if I've misunderstood, I'm happy to offer any further clarification.
No,
okay,
that's
thanks,
not
David.
Fine, David.
Okay. Any other? Councillor Jenkins, Gordon.
Yeah, two questions, if I may, Chair. Craig, you said when you were talking there that the matter had been deemed to be not adverse, but deemed, is that a matter of opinion? I mean, right through this document, I hear things like it's deemed that this isn't against a policy, but is deemed not a matter of opinion. And I'm sure the planning official holds those views sincerely, but they are a matter of opinion, and this committee could deem otherwise.
Chair, can I take that one to refer to both Craigs? Yes, Councillor Jenkins, that is exactly right. It is based on assessment. It is a question of comparing somebody's development proposals against the relevant policies, and the policies are set out there. There is always a matter of interpretation. What do those policies mean? What do I understand them to mean? What am I applying to the particular proposals in front of me? There's the interpretation element, and then there's the consideration of the proposals. Sometimes, depending on the nature of the application, and I'll take you away from housing, you know, as members will recognise, we're sitting here with very, very complicated wind farm issues with the length of the height, the width of the blade, the length of the blade, the impact of the lights. We got 190-page reports in these matters, and I find it hard, and I'm sure members from a lay perspective find it hard to actually, you know, form an alternative view, because there are occasions when you may feel you are beholden to the technical expertise and knowledge of the officers. But ultimately, it is a matter of the exercise of professional judgment. And in some cases, it's the case where, and it's not for officers to impose those views, but sometimes on the facts of the development proposal, there isn't always a lot of room within the policy for an alternative view to be taken at this stage. But sometimes, depending, then the situation can be quite different. The position here is that you've seen the pictures, members, at the beginning, and you can see what it currently looks like. And as Mr. Hannah made the point, they are recent pictures, so it looks a lot better, no doubt. In the summer would be his point, and nobody's going to argue with that. That's a fact of nature. So the bottom line is you can see what's there just now. You've seen the plan that Craig Thomas put up at the beginning that would show where these driveways would sit if this goes ahead, subject to either resolution or what have you. But the bottom line would be, this is an instance where, as members, there was an opportunity for the site visit yesterday. I know some went, so you've seen it for yourself. If not, you've certainly seen the pictures in quite a lot of detail about what it looks like just now, what the impact would be in existing houses, and what the proposal is. So while neither buying or selling the alternative view, I believe this would be a situation where, if members were of the view, leaving aside the ownership interest, if a member was of the view, having seen the pictures, knowing the site for themselves, that they came to a different assessment or consideration in relation to OP1, Res 1, Res 11, DMV 9, then I don't believe that would be so off the page that it would be unsustainable as stateable planning grounds, which, as members know, is the test for moving any decision either way on any application, is that there are stateable planning grounds. Mr. Hannah has suggested there are. If members accept that, and that's a matter for members, as I said, we're neither buying or selling, but if members are of that view, then I believe they would be entitled to vote that way. If members accept, and having gone through the same process, read the same report and seen the same information and heard the same representations today, if members accept the judgment of the planning officers, they've been entitled to move for the recommendations. I'll leave it at that, members.
Okay, thanks, David. So you're coming down.
Can I ask a second question then?
No, that's okay. I think in regard to the first question, you're coming down to the professional opinion of the planning officers, the planning department, having applied necessary due diligence in terms of the application.
And I would always take a deep breath before I went against the planning officer's recommendations, but it is possible. That's what I wanted to know. Okay, so my next question is paragraph 166, where it talks about potential financial implications if we're minded to refuse this proposal. It's a wee bit like putting a gun to our head, but I mean, we've seen this paragraph before, so I know it's a standard thing that goes in there. But if we actually give approval here, could the objectors not appeal? And would that not take us into the same? Would that not take us into the same area where we could end up in court about this?
Through you, Chair, in terms of the planning legislation and the planning framework, objectors have no automatic third-party rights of appeal against any decision of the planning authority. However, that said, clearly there may be other legal routes that may be available to the objectors if they were so minded to do so. through whether it be the Court of Session primarily or otherwise, through other even internal routes within the council, like a complaint route. But certainly there is no third-party right of appeal. The only basis upon which they would look to do so is if ultimately they took the view that the council had not acted in a reasonable manner in the consideration of this application, and by pointing to irrelevant planning matters or irrelevant matters that have been taken into account in the determination of this. As members are very clear, what you require to do today is assess this on its particular planning merits. In doing so, you need to be seen to be clearly acting reasonably, but also taking into account relevant material planning matters as part of that process. And as long as you do that, then quite clearly, the risk of challenge is certainly minimised. Whilst I can't say it would never happen, that's a matter for others. But certainly, if you take that course of action, it would certainly be minimised, and it would certainly be the position that in that event, by assessing it on its proper planning merits, acting reasonably, taking account of the relevant considerations, then certainly, should those challenges come, then we would be certainly in a strong position to oppose them or defend them.
Okay, thank you, Craig. But I take it from what you've said, we could end up in court either way.
They would need to point to an unreasonable act by the committee, and quite clearly what we have done is we have set out a report, Councillor Jenkins, that clearly sets out all the planning considerations for members today in coming to a view.
Yeah, Craig, I'm not questioning whether it would be successful or not. I'm just saying it's possible. Thank you.
Okay, folks.
Sorry, Chair David.
David.
Yeah, just
David, sorry.
Yeah, thanks, Chair. A, just to support and endorse all of Craig's comments, and B, not to try and improve on it or top it, simply to try and summarise. If this committee should grant this application today, the owners, the residents, Mr Hannah and the other 12 parties would have, may have the option, and I'm talking about process, to either judicially review the decision in the Court of Session, that's what Craig's referring to, and a judicial review is based on the Administrative Act, if you like, and the Wednesbury Principles. So we would need to be able to demonstrate that we've acted lawfully, which I think we have. We've acted within policy. I think the officer's recommendation assessment are, which is not to negate an alternative decision. I think reasonableness, rationality, etc., the consistency, then we would not be putting this up here if we didn't think it was defensible as it's presented. But that doesn't mean it's the only option for the committee. The other option for the residents, if this is granted, would be not to attack the decision, but would be to basically defend their property rights and to initiate appropriate legal proceedings to defend their property and prevent any third party without the necessary rights to come onto their land and carry out any works that they've no right to carry out. That's the impact of the property. And for finality, just to be absolutely clear, because I'd hate it to be misquoted, as far as I'm concerned, the legal ownership is a material matter. It is not insignificant. People sometimes think when you say it's not a material planning consideration, you're saying it doesn't matter, it's not a material issue. Clearly, it is going to have a major impact on the outcome of this development, one way or the other, almost regardless of what decision you take today. But it's not a relevant planning consideration. So it's not about it not being material, it's about it not being related to the planning position. And sorry to belabor that point, but I do want to be absolutely clear that we're not saying there's no issue here. There's an issue, but it's not an issue that falls to you to take account of in determining it. You determine it on the planning matters that have been set out by my colleagues and myself and the parties in the course of the proceedings. And we'll leave it at that. Thanks, Chair.
Okay, thanks for that, David. Okay, anybody else? Councillor Cook, Tom.
Thanks again, Chair. I'm just again thinking, in terms of any possible legal challenge. Mr Hannah, I think, mentioned in his presentation that the council were going to get substantial amount of money from the developer, but that hadn't been taken into account in the papers that are presented to members today. note that. I take it that would be developer contribution he was referring to, and is not a material point for us to consider.
To be honest, Chair, and I don't want to fall out with anybody, but I'm disappointed Mr Hanna chose to make that remark, given Mr Hanna's stated credentials, which I absolutely accept, and knowledge and wealth of experience in his in planning matters and his job roles in planning matters. Then Mr Hanna knows that the developer's contributions is a natural part of the overall statutory planning framework. It's provided for in the local development plan, etc., and everyone understands, I believe, normally that if a development goes ahead, then it may yield contributions. But granting a consent doesn't automatically mean a development will go ahead. And I believe as planning authority, we have always been quite clear that we have set about and have delivered on assessing and providing recommendations to the committee. And I think in turn, to be fair to the committee, I can't recall a planning committee in the life of East Ayrshire Council being swayed with the possibility of a developer contribution when any application has been approved. So factually, that's correct. If this goes ahead, there'll be a developer contribution, but we conduct our business in an open and transparent and accountable fashion, and that it can all be seen to be there. It's not a hidden secret interest, it's not an inappropriate interest, and it's certainly not anything that has informed the planning assessment of this application.
Okay, Councillor Cook.
Yep, thanks very much, David.
Okay, I'm not seeing any further hands. Okay, members, can we move to determination now, please? Can I have a proposal? Councillor Todd.
Thanks very much, Convener. I'm going to propose refusal, and the reason being, as I alluded to earlier, that there's a resolution, a very easy resolution to this, but I'm going to propose refusal, principally on reduction of visual amenity. The residents have been there for 20 years and they had that strip of land. It's a green space. They've enjoyed it for so long, and I'd like some advice for the officers on what part of that was Res 1 or OP1. But I'm going to propose refusal. Thank you.
Okay, Councillor Todd, I think I need a bit of elaboration on in terms of the policy, local development plan.
Yeah.
To make it a competent.
No, it's the loss of green space and landscaping. They've enjoyed that for 20 years, taking away all the legal aspects and all the argument with who owns what. This is a green area. Planners know that I always support green spaces and try to look after them. So I need some advice from officers how I can put that forward in terms of protecting that green space, because I was a wee bit mixed up in terms of some of the dialogue where they said there wouldn't be any impact, but obviously there would be if there's going to be runways and a drain. You take away that green aspect of the tree line. If the proposal is going to have houses with their fronts leading into the existing street, then obviously you're removing a visual amenity.
Chair, through you, in recognition that it can be difficult for my planning colleagues to put forward one view and then be put in the position of articulating an alternative view, then I believe the answer to your question, Councillor Todd, is that you find there is merit in the submissions made by the objectors, and you are endorsing the view that was put forward that this is not fully in accord with policies OP1, Res 1, Res 11, and potentially I think it was DMV 9, and it's on that basis that you're not persuaded with the merits of the application and you're moving to refuse. Is that correct?
Okay, do I have a seconder?
I'll second, Councillor.
Whose hand was up first?
Councillor Cooks, I believe, but we do have it seconded now by Councillor
Friel. Right, okay.
We also have Councillor Cook and Councillor Maitland with their hands up, Chair.
Okay. Sorry guys, just need to underline this. Right, okay, hands up. We have we've got Councillor Jenkins, Councillor Cook, Councillor Maitland. Okay. Councillor Cook.
Thanks, Chair. I would like to move the application for grant, to grant the application, understanding that there's a lot of legal issues in here. It may never actually proceed unless these can be resolved. But in terms of the planning process itself, I don't find any reason to object. I agree with the authors of recommendations and therefore move grant.
Okay, do you have a seconder?
Maitland's hands up, Chair.
Councillor Maitland. Councillor Maitland.
Thank you, Chair. It wasn't to support anybody at the moment. It was actually to ask Councillor Todd if this was specifically related to Res 11 that his objections arose. Thank you.
Councillor Todd, can you elaborate on that? We're at determination, guys. We've had the chance to answer questions, etc. We should know our planning policy.
Yeah, no, that's it was those that was raised by the objector, and I think they all fit within the proposal, and that's the basis on my view.
Okay.
Okay, so we have a counter proposal from Councillor Cook. Does he have a seconder? Okay, I will second Councillor Cook in regard to approval. Okay, we have two motions, so Lynn, I'll pass over to yourself in terms of a vote.
Thank you, Chair. Members, for clarity, the motions and amendment that we have in front of us is a motion by Councillor Todd, seconded by Councillor Friel, to refuse the application due to the reduction of visual amenity, loss of green space and landscaping as a result of the policy being contrary to policies OP1, Res 1, Res 11 and ENV 9. The amendment is by Councillor Cook, seconded by Councillor Roberts, to approve the application for the reasons in the report, including the conditions and advisory notes, and that includes the withdrawal of conditions 1 and 2, as previously indicated by Craig Thomas earlier. In terms of the vote, members, for clarity, when your name is called, can you confirm if it's for the motion or for the amendment? The motion being refusal, the amendment being approval. Councillor Roberts.
For the amendment.
Councillor Jenkins.
Motion.
Councillor Friel.
Motion.
Councillor Cook.
Amendment.
Councillor Maitland.
Amendment.
Councillor Todd.
Motion.
Councillor Bell.
Motion.
Councillor Filson.
Motion.
I can confirm that the motion has been carried by 5 votes to 3 and the application has been refused. Thank you, Chair.
Okay, thanks very much, members. We'll just wait till the public gallery clears and then we'll go on to the next item of business. Okay, folks, we'll reconvene. Galleries are now clear, and we'll go for item 4 on the agenda, is the inclusion of additional conditions to 190262 PP, planning permission for proposed new hard rock quarry and associated access, processing plant, welfare facilities, settlement lagoons and bunding at land at Dareduff Hill, C7 Dunlop to Neilson, from A735 near Dunlop to East Renfrewshire boundary, Dunlop, East Ayrshire, pages 64 through 156. Graham.
Thank you, Chair. Good morning, councillors and everyone in attendance. This is a report being presented to you today to seek your agreement for the inclusion of 2 additional conditions in respect of a major quarry development application which was previously considered by members at the 19th of March 2021 Planning Committee. The development itself was dealt with under Planning Application 19/0262/PP and was for a proposed new hard rock quarry and associated access, processing plant, welfare facilities, settlement lagoons and bunding at land at Dareduff Hill next to the C7 road which runs between Dunlop and Neilston. Members agreed with the recommendation to approve the application subject to 40 conditions and a legal agreement on the 19th of March 2021 Planning Committee, and a copy of that committee report has been included as an appendix within your papers today. While work is ongoing and progressing on the legal agreement, further consideration was given to the conditions, and it was felt there were a couple of matters which could be improved upon in relation to the waste management plan and implementation period for the commencement of the development. Paragraph 6 of the report sets out the 2 proposed conditions which you are being asked to agree to today. Condition 41 relates to the waste management plan. Whilst a waste management plan was originally required through Condition 16 as part of the Construction Environmental Management Plan, there is specific wording regarding waste management plans for extractive waste set out in the Management of Extractive Waste Scotland Regulations 2010. It was considered the wording now proposed within your committee report today would better reflect that which is set out in those regulations and would provide a greater distinction between the 2 different types of waste and their respective management plans. The original waste management plan required through Condition 16 will remain relevant for general waste arising through the construction of the development, whilst the wording proposed at Condition 41 will ensure that waste arising specifically through extraction operations at the quarry are dealt with appropriately in line with the waste management plan specific to the extractive waste. So that just provides a greater distinction between the 2, and we would then have 2 conditions which would address those fully. Proposed Condition 42, which is also within paragraph 6 of the report, is required as ordinarily Section 58 of the Town and Country Planning Scotland Act 1997 as amended by default requires development to be commenced within 3 years of consent. Section 58 Part 4, however, notes that Section 58 does not apply to temporary consents. As the quarry would be a temporary consent with a limited operational lifetime, then the default 3-year implementation period to commence development would not apply to the quarry application. As such, we are required to include a condition specifying the time period to commence development. The proposed conditions 41 and 42 before you today are considered to suitably address these matters, and for the reasons set out in the report, it is recommended that members agree to the inclusion of these conditions in the subsequent decision notice for application 19/0262/PP once consent is issued. Thank you.
Okay, thanks very much for that, Graham. Okay, members, there's no hearing. It's just a case of having a look, see if you get any questions in terms of clarification from Graham's report. Anybody get any questions? Nope, I'm not seeing anything. Kerry, anything in terms of roads? No. No legal implications, bearing in mind this has been before us?
No, Chair. Essentially, it's a tightening up and clarification on conditions that were previously before the committee earlier in the year.
Okay, thanks, folks. Okay, members, are you happy to agree? Okay. So thanks very much. Okay, guys, thanks very much for this morning. Thanks for your input and your attendance.
Chair,